We have to talk about the Hunter Biden gun trial in the District of Delaware, U.S. District Court. We're going to talk about the legal issues and some of the factual issues. It's really a terrible case from Hunter Biden's point of view factually, but does he have some legal arguments? Let's chat about it when we get back. Hey folks, I'm Mark Smith, host of the 4 Boxes 9, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Israel Disarmed: What the October 7th Attacks on Israel Teach Americans About the Right to Bear Arms. We want to learn the lessons of others, the mistakes of others, so we don't make them here. The importance of armed citizens and not being dependent upon government to protect us. Mission critical to understand. Our founding fathers understood this entirely. Unfortunately for the Israeli citizens, they became complacent and deferred too much and thought too highly that their government would protect them. And October 7, 2023, turned out that was not the case. A lot of lessons there about the right to keep and bear arms, the context of Israel, and the lessons that we here in the United States can draw from it. A lot of critical information, historically and otherwise. Check out Israel Disarmed, my latest book on the Second Amendment. All right, folks, so we have to talk about Hunter Biden. As you know, we've covered the story a little bit before. Hunter Biden is the son of Joe Biden. Hunter Biden is asserting various Second Amendment rights, even though Joe Biden, as a continuation of Barack Obama, is the most anti-gun, anti-Second Amendment president in American history. Whether or not he knows it, I don't know, but his actions speak to everything they can do to stop the right to keep and bear arms they are trying to do. Ironically, of course, Joe Biden's son Hunter is asserting Second Amendment rights and trying to defend his right to keep and bear arms. Now, I want to just talk about the two big pictures here. One is legal questions, and the other is sort of the facts. Legally, of course, we've talked a little bit about this before, that under the Second Amendment, you have a right to keep and bear arms. The people have the right to keep and bear arms because Hunter Biden is a citizen of the United States. He is obviously part of the people, i.e. the right of the people to keep and bear arms. That means the right of Hunter Biden to keep and bear arms does exist. So textually, he's part of the people. Now, I pointed out that I think that ultimately the Supreme Court will find that nonviolent felons and people that are not violently dangerous have a right to keep and bear arms. People that are found to be physically violently dangerous or a risk of physically violent dangerous conduct, either toward themselves, i.e. a suicide risk, or toward others, the risk of murder, rape, robbery, whatever, terrorism, those people will be disarmed. The question is the drugs. Now, I think it's pretty clear to me, based on the United States versus Brown case of last week, that drug traffickers and drug dealers are going to be viewed as people that are physically violent, dangerous to society, and therefore they can be disarmed. Drug users, I think, is a more complicated question. I think if it may very well turn on the type of drug one uses. Again, the drug issue in the Second Amendment, I think, is multiple years away from resolution by the U.S. Supreme Court. So everything we're discussing now about drugs and the Second Amendment is in many respects kind of very speculative and hypothetical and in fantasy land to some degree. And I'm not here to denigrate the issue legally or anything like that. But what I'm saying is there's so many other Second Amendment related cases that are coming down the pike over the next couple years. I don't really see a way that a Second Amendment case touching on whether or not people that use drugs or are addicted to controlled substances, whether or not they're going to be able to have guns, or whether or not 18 U.S.C. 922G is unconstitutional as applied to them. I just don't see that issue coming to the Supreme Court for several years. So we're all talking generally about what the law is here, but certainly as a consequence of what I just said, for the moment, we have to assume that 18 U.S.C. 922G has applied to people that use illegal substances, controlled substances, are addicted to controlled substances. They're not going to be allowed to possess firearms in the near future. I don't think the Supreme Court is going to knock that out anytime soon, and I don't think they will ever actually knock out the entire statute facially, but they may knock it out with respect to certain particular individuals, which is why I've explained before that the type of drug one is addicted to at the time they possess the firearms could conceivably be a material factor in whether or not they challenge to the drug-related prohibited people provisions of 18 U.S.C. 922G might play a role. For example, if you're addicted to crack cocaine or cocaine, that may be more likely that you'll be allowed to be viewed as disarmed because you're viewed as a violent danger than if perhaps you are using marijuana subject to a state medical marijuana card. Again, I'm speculating here, but I do think it's possible the Supreme Court could draw those distinctions down the road several years when it comes to drug use and the Second Amendment. But with that said, from Hunter Biden's point of view, he is definitely arguing Second Amendment issues. Whether or not, if he's convicted, he will certainly assert robustly the Second Amendment on appeal. If he's found not guilty, or the case is hung with a hung jury, and they don't retry it, then it will kind of be a moot point because he will have gotten off, or that'll be the end of it. So the Second Amendment issue with Hunter Biden will go away to the extent it's either an acquittal, which is quite possible because Wilmington, Delaware is literally Biden land. This is literally, I believe, the name Biden is on buildings in Wilmington, Delaware. He is the favored son of Wilmington, Delaware. So it's kind of like the flip side of the Donald Trump case, which is really like a crappy case in a terrible jurisdiction against Donald Trump. In contrast, I think it's fair to say in the Wilmington, Delaware situation with Hunter Biden, it's a very powerful case, and we'll get to the facts in just 1 second. It's a very powerful case factually, in my opinion, but it's in a jurisdiction where you could see a form of jury nullification where the favored son, Hunter Biden, is let off by a Wilmington jury that basically says, let him go because we like him. Quite possible. With that said, that's where I think the constitutional issue lies, and generally speaking, the factual issues. Now, let's just talk briefly. Now, just as a reminder, Hunter Biden has been indicted for possessing a firearm while being addicted to and or using illegal substances. Now, here is what the form asked him, and this is what he checked. Specifically, he checked, no, that he's not addicted. Let's go to the graphic, and you can see what it said. Question 11E asked Hunter Biden, quote, are you an unlawful user of or addicted to marijuana or any depressant, stimulant, narcotic drug, or any other controlled substance? Warning, the use or possession of marijuana remains unlawful under federal law, regardless of whether it has been legalized or decriminalized for medicinal or recreational purposes in the state where you reside. So that's pretty clear. And the question is, was Hunter Biden addicted to drugs, or did he illegally use drugs? When he said no, because he answered the question, no, I'm not addicted. I don't use illegal drugs. But of course, it's pretty clear based on the record that I've seen, that's false. To begin with, his memoir, I think it's called Beautiful Things, was played, the book on tape or the audio tape or the audio recording, whatever you want to call it, depending on your generation, was played for the jury where he literally says in 2018 he was addicted to these substances. He was using these substances, and he talked about it. He basically put it out there for the world to know in his memoir, which I think was published in 2021. Beyond that, we know, based on the testimony of 3 women close to Hunter Biden, his ex-girlfriend, Zoe Keston, testified where they met at a strip club, I think in 2017, and they dated for many months, that in 2017, 2018, which is before the gun purchase, Hunter Biden was addicted to various drugs and used various drugs, and she allegedly helped him acquire drugs through drug dealers. Then you have the testimony of Hunter Biden's brother, Beau's widow, who, guess what? Hallie Biden dated, after the death of her husband, Hunter Biden. So it's a weird situation, but that's nevertheless to each his own, I suppose. So Beau Biden's widow testified that Hunter was using drugs in 2018. And remember, it was Beau Biden's widow, Hallie Biden here, that said that she's the one that found the gun in October 2018 like 11 days after Hunter had bought the gun from the FFL, she found the gun and she threw it in the trash bin. And of course, it was eventually found by somebody searching through the trash for items of interest. And he captured the gun and eventually gave it to police because I think he was identified on a security camera outside of the grocery store that was focusing on that trash can. So anyway, so you have at least 2 witnesses plus a memoir saying that he was using drugs in 2018. Another critical damning piece of evidence is his ex-wife, Hunter Biden's ex-wife, Kathleen Buell, testified that he was always using drugs for a substantial portion of their 20-year marriage. And last but not least, and I think this is particularly damning, that Hunter acquired the gun on October 12, 2018. And on October 13, 2018, there's a series of text messages that the government put into evidence to show that Hunter was trying to acquire drugs or was acquiring drugs on October 13, 2018 from a drug dealer named Mookie. So he's literally communicating with this alleged drug dealer named Mookie the day after he bought the gun, which was a Colt revolver, by the way. And of course, it's pretty clear, according to the testimony of the FFL employee, the gun dealer employee, who said he watched Hunter Biden fill out the form because that is his practice. He watches people fill out the form to make sure they're doing it right or if there's an issue and whatever it is. And he remembered this because he testified that he was a car guy and a gun guy, and Hunter Biden drove in a particular kind of car that he thought was cool. So he remembered this transaction in a way maybe he did not otherwise. As a side note, apparently there is now evidence, this came in, that the Secret Service, by the way, went to the FFL to try to get the 4473 record, and the FFL gun dealer wisely refused to turn it over to the Secret Service. Now, as to why the Secret Service was trying to get the 4473 form from the FFL, I'll let you speculate, but I have a feeling that the reason why the Secret Service got involved with the situation was an attempt to protect the Biden family by trying to get that 4473 before anybody could be done with it. And I have to give kudos to the gun dealer FFL for refusing to turn over that 4473 form involving Hunter Biden to the Secret Service and told them to basically go pound sand, which is the correct answer, I believe, because the Secret Service, without a warrant, has no authority to do anything in the context of guns. That is the realm of the ATF. And again, there was no search warrant and no arrest warrant that the Secret Service brought in. They apparently just came in and says, hey, we'd like the form, we'd like the document. And the FFL says, I'm not turning that over to you. Good for the FFL, good for the gun dealer. Very smart, because if they'd done that, who knows what would happen to them. So it's good to see American gun dealers following the law, which I think happens all the time, every day, contrary to what the anti-gun Biden administration likes to say. So to summarize, where we stand with this Hunter Biden case is, as a matter of Second Amendment, if he's convicted, he's going to really press that argument on an appeal. I'm not sure how far it's going to get him based on the fact that he was using crack cocaine as opposed to, let's say, marijuana. So I think his case is not going to be particularly sympathetic. Moreover, factually, it seems pretty clear that he was using these illegal substances and was addicted because they have very strong testimonial evidence, including his own words in the form of the memoir and text messages and so on, both before October 2018, which is before he acquired the gun, and after 2018, after he acquired the gun. So if you combine all of this, it's going to be, I think, factually very difficult for Hunter Biden to win this case. And his lawyers, Abby Lowe, a very high-end lawyer, I'm sure will do the best he can do to raise issues and questions of credibility and whatnot in this case, which is what he's supposed to do. But at the end of the day, I suspect Hunter Biden should be found guilty based on the record that I've seen. But, you know, we're not in the courtroom. We'll see what happens. And again, I do think there's a real possibility of that jury in Wilmington, Delaware, which voted overwhelmingly for Joe Biden in the 2020 election over Donald Trump. I do think there's a real possibility that that jury will vote to acquit Hunter Biden or be hung, meaning there'll be some holdouts to say, I'm just not going to convict him. And there is a tradition in the United States of jury nullification where the jury just can say, we're not going to convict because we're sympathetic to him or whatever it is. And again, the judges don't like to hear that sort of thing because they want you to follow the law and follow the instructions. But the reality is people are people and sometimes they don't. And I'm not saying it's right or wrong, but the reality is there could be a form of jury nullification here where the jury just refuses to convict Hunter Biden for various reasons, either because they're sympathetic toward the fact he's an addict or was an addict. Number two, they just don't want to punish Joe Biden because they know politically it will hurt Hunter Biden's father, and they don't want him to lose because they're fearful of Donald Trump. Or they just may conclude that the Biden family has done a lot of good work, brought in a lot of money from the federal government and so on, and they don't want to do anything to hurt the family, and they feel like this is just, putting salt in the wound or whatever it is. Again, one doesn't know. I'm not on the jury. I'm not in the courtroom. One never knows what the jury does, but these are the sorts of things that could occur. And again, we'll keep you apprised as this case progresses. As to an appeal, I don't think Hunter Biden's a particularly sympathetic case to go up to the Third Circuit Court of Appeals to vindicate our Second Amendment rights. So from a pure Second Amendment vantage point, I would prefer Hunter Biden not to be the test case because I don't think it will end well for us. But only time will tell. So there you have it, folks. Hope you learned something here today. Make sure you follow me on X at @4boxdesigner, and please subscribe. We're trying to get to 150,000 subscribers on YouTube, and don't forget to check out my book on Amazon, Israel Disarmed, about how they disarmed their citizens, even though a lot of those citizens had served in the IDF or the military, and yet as civilians, they made it pretty hard to get guns. A lot of great information in that book. Check it out. You'll learn a lot from it and learn what not to do, which is sometimes more important than learning what to do. So there you have it. Okay, folks, we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.